Hey everyone, welcome back to my channel Beyond the Briefcase. I hope you're doing well. So today I am back with a unique uh, concept, which is doctrine of severability in ADR, a comprehensive overview. Initially, when I searched for this particular topic in the YouTube, I did not get various relevant videos. So I thought to make a comprehensive video on this particular topic, which is very useful when you reach third or fourth year of your college. So let's see what exactly this concept is and how we can deal with it. So when we study doctrine of severability, it does have connections in area. We do also study doctrine of severability under Article 13 of Indian Constitution, Article 13 Clause 1, Article 13 Clause 2. It also has roots in Contract Act as well. So it's a very interconnected concept. So doctrine of severability in ADR is also known as autonomy of arbitration clause. Now, we all know that arbitration clause is a part of main contract, but it is also being considered as a separate from the main contract. Also, on the account of invalidity, when we talk about invalidity, breach, or termination, the arbitration clause survives. That's why it is being called as autonomy of arbitration clause. Now, moving ahead, also during this particular comprehensive review, we'll be covering various landmark case laws, international perspectives, and practical applications as well, because ultimately, someday you might get a chance to draft various arbitration agreements in which you will definitely include arbitration clause. So, this particular things become very useful for you in future as well. So this is a synopsis which I have prepared that we would be covering all these things in this particular video, which is definition, essentials of severability, relevance of severability, doctrine of severability. So please don't get confused. It's an abbreviation of doctrine of severability (DOS) in arbitration. Section 89 of CPC, Section 89 of CPC deals with ADR. Also, this particular section was proposed by the Malimat Committee. Now, I'll tell you the reason why Section 89 CPC was introduced. Because, see, when we see the number of cases pending in the Indian courts and the ratio of judges, it's huge. There is huge difference between the pending or number of pending cases and the ratio of judges. So, initially, legislature thought that by bringing ADR, what we can do is we can settle various cases outside the court, due to which we will be able to tackle the number of pending cases. So that was the initial intent behind bringing section 87, 89 of CPC. Then we'll be discussing first case of severability in arbitration in India, KK Modi and versus KN Modi 1998. Then another case law, Prima Paint Corporation versus Flood 1967. We will definitely going to see illustrations of doctrine of severability in arbitration, doctrine of severability in unilateral model law, Article 16 of unilateral model law, which talks about the same. Application in practice, as I mentioned, how to use this particular doctrine in practical aspect, impact of ADR process. Then I have kept two papers, and both are Scopus Index papers, which deals with this particular concept. So we'll be discussing that as well. And I have prepared some of the questions which you might get, and I have prepared answers for that also. So let's start with this particular concept, starting with the concept of doctrine of severability. So, as I mentioned, doctrine of severability is also known as autonomy of arbitration clause. Arbitration clause is a part of main contract, but we it is also being considered as separately from the main contract on the account of, as I mentioned, termination, breach, invalidity. If it happens, but arbitration clause will survive. Also, if we talk about the purpose of doctrine or severability, the primary purpose of DOS is to preserve the original intent of the involved parties. Second, being to preserve validity of the agreement. Also, to see dispute resolution goes efficiently. Moving ahead, important definitions. Now, Section 2A of Arbitration Conciliation Act 1996, which deals with arbitration It means arbitration whether or not administered by a permanent arbitral institution. Basically, it's a body. Then Section 7 of arbitration agreement. In this particular part, arbitration agreement means an agreement by which parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. So I have highlighted certain parts of Section 7 which are very important from the perspective of this particular concept. An arbitration agreement may be in form of arbitration clause in a contract or in a form of separate agreement. Separate agreement. Then the third point, arbitration agreement shall be in writing. Then clause 5 and clause 5th. Also, section 16 of, I have not mentioned section 16 here. I did mention that section 16 in the further slides. But keep in mind that section 16 of Arbitration Conciliation Act 1996 talks about arbitral tribunal competency and its jurisdiction. Then moving ahead, just a second, I'll try to, uh, I'll, it's okay. So let's move forward with the concept. So, essentials of severability. The first being clear contractual language. Now, whenever we are drafting any agreement, the language has to be very clear and accurate. Otherwise, it definitely creates a huge issue, such as interpretation, which could happen in the future. Second, intent of the parties. Now, intent of the parties should be extremely crystal clear whenever we get into the agreement. Third, being public policy, enforcing the remaining agreement portions must not violate public policy. This ensures legal and ethical compliance. So, compliance becomes very integral part of the agreement, and it has to be keep in mind while drafting the agreement. Relevancy of doctrine of severability, first being effectiveness, second being application, third being consideration. Also, we all know that severability is a cornerstone of modern arbitration law. It promotes the effectiveness, integrity of ADR consistently applied across jurisdiction. So why effectiveness? Because doctrine promotes ADR effectiveness. Also, as you all know, that doctrine of severability, it's a universal concept and it's being followed by almost various countries. And when we talk about consideration, it becomes very essential part for the agreements drafting. Now, doctrine of severability in arbitration, that's what we are discussing. So in arbitration, this doctrine means that an arbitration agreement is treated as separate from the main contract, as I just mentioned. If the main contract is void or unenforceable, the arbitration clause can still survive, allowing dispute resolution through arbitration, which I mentioned in the initial slides. Legal basis, section 16(1)(a), which I was talking about, of the Arbitration Conciliation Act 1996, establishes the competence principle, which allows an arbitral tribunal to rule on its own jurisdiction. Also, it gives a power to the arbitral tribunal to function on its own and to avoid any intervention of the court. The arbitration agreement is treated as independent from the main contract, which again I mentioned. Then the first case of severability in arbitration in India, KK Modi versus KN Modi 1998. So I'll tell you the small gist of this particular case. So there was a family dispute, and one of the party claimed that the whole agreement is void. Now, the what was the court's ruling? So the Honorable Supreme Court of India applied the doctrine of severability and held that even if some parts of the contract were invalid, the arbitration clause could stand independently. The court reinforced that arbitration clauses are treated as separate agreements and can survive even if the main contract is void or unenforceable. Again, the principle established, doctrine of severability, which we are talking about. So, do remember this case law. It becomes very important because that was a first case law of severability. Moving ahead to the next case law, Prima Paint Corporation versus Flood and Conclean Manufacturing 1967. The U.S. Supreme Court held that the doctrine of severability becomes very important, and this particular doctrine applies in the arbitration. Severability, the ruling held that arbitration clause is separable from the main contract, and implications, challenges to the contract's validity don't automatically invalidate the arbitration clause. So that was the whole case about. Now let's see the illustrations of doctrine of severability in arbitration. The example number one: contract for construction with defective payment terms. A company signs a construction contract with an arbitration clause. If a court finds that the payment terms illegal, the arbitration clause still remains valid, allowing dispute resolution through arbitration, which just now I mentioned, that it doesn't matter whether your agreement is valid or not, but your arbitration clause will survive. Example number two: unilateral appointment of arbitrator. A contract contains an arbitration clause where one party has the exclusive right to appoint arbitrator. The Supreme Court in Perkins Eastman Architects DPC versus HSCC India Limited 2020 struck down the unilateral appointment clause but upheld the arbitration agreement by allowing an independent arbitrator to be appointed. So do keep this thing in your mind. Moving ahead, separability in unilateral model law. I'll make a small correction here. Sorry for the disturbance. Just bear with me. Severability in unilateral model law. Article 16, as I mentioned, it deals with doctrine of severability. Also, uh, we also call it as separability. The impact of doctrine of separability on all the laws. Article 16 of unilateral allows tribunals to rule on their jurisdiction. This also includes raising any objections to the arbitration agreement's validity. Then comes application in practice, how to use doctrine or severability clauses. So the first thing you need to make sure comprehensive language. In the above slide, we saw that language plays a very important role. So make sure whenever you draft any agreement that your language should be very clear and it has to be crystal clear so that you can easily avoid any interference or any interpretation issue in the future. Second being accuracy, accurate clauses has to be used. The third being clear intent. Your intent has to be very clear, and use broader language, ensuring remaining provisions stay effective, address potential issues like governing law and jurisdiction. That's very crucial for any of the agreement. Impact on ADR process. So it promotes efficiency, reduce court intervention, increases enforceability, provides certainty for parties, supports party autonomy, respects arbitration agreement. Now coming to the article segment, I'll show you the article which I have mentioned here. This is the first article. It's a Scopus Index article, very amazing article. So, doctrine of severability and analysis. So, I'll tell you the epitome of this particular article, which is totally based on this concept, but it is related to constitution, not to ADR. So, this particular article was written by Mansi Pahel, which explores the principle that unconstitutional provisions within a law can be struck down while preserving the rest of the statute. So, let's say if there is some of the provisions of the law is conflicting with the fundamental rights, which is also rooted in Article 13 of Indian Constitution, then this particular doctrine of severability safeguards fundamental rights. Also, this paper examines judicial interpretations, limitations, and comparative perspectives, emphasizing its role in maintaining constitutional integrity while ensuring legislative intent. So, this was the gist of the first paper which I showed you right now, and this is the second paper which specifically deals. This is the second paper which deals with the doctrine of severability and competence under the constellation of Indonesian arbitration law. Here is the article. It's a 14-page article, amazing article. They have mentioned almost everything. So I'll tell you the epitome of this article. This article examines the doctrine of severability and competence, section 16 of Arbitration Conciliation Act, article 16 of unilateral model. It highlights severability's role in maintaining arbitration agreements despite invalid principal contracts, discusses competence partial adoption, limiting tribunal authority to decide jurisdiction. So this was said in this particular article. Now let's see the first question which comes in our mind, that can an arbitration clause survive even if the main contract is found to be void or unenforceable? And what legal principle govern this? Yes, an arbitration clause can survive even if the main contract is declared void or unenforceable. Second, the legal principle that governs this is doctrine of severability or severability, which we learned just now. This principle recognized in international domestic arbitration law such as unilateral model law. Various national arbitration statutes ensures that arbitration clauses remains valid unless the arbitration agreement itself is specifically invalidated. Second question, if an arbitration clause is a part of larger contract and the contract itself is declared invalid, and should the arbitration clause also be considered invalid, and why? So the response would be no, the arbitration clause should not automatically be considered invalid. Under the principle of severability or autonomy of arbitration clause, which I mentioned, of the arbitration agreement, an arbitration clause is treated as an independent contract from the main contract. So I hope you must have got some idea about this particular concept, and it's a very useful concept. Be Doesn't matter whether you're in college, whether you're practicing, but you should know about this particular concept. So if you like this video, do share with your friends. It's a very important topic, and do like and subscribe my channel for more informative videos. And I would love to hear from you people. If you want me to make video on any specific topic, I would love to hear that, and do suggest me. I always welcome constructive criticism from you all, and do let me know whatever you want from me, and do share this video with your friends as much as possible. And thank you so much for watching my video. Thank you so much, people.